Hi, Tony DeWitt here. Hi. Chicken soup. Hi, Tony DeWitt here, Missouri appellate attorney and a guy who's not got half of a voice today. But this was important and I wanted to get it out. About 4 years ago, we were able to watch the live streamed trial of Christopher McNabb and Cortney Bell. In case you don't remember what this murder trial was about, here's what the prosecutor said in opening.
On September 23rd, 2017, at 9:53 p.m., Kalia Claire McNabb came into this world weighing 6 pounds and 6 ounces. She was a little premature, but otherwise a healthy baby. The evidence will show that just 14 days later, her father, Christopher Michael McNabb, ended her life so abruptly and with such teeth came through her gums and into her tongue. You'll hear that she was then later left out in the woods, wrapped in clothes and a blanket. She was stuffed into a bag. She was put under a log, in a hole, and left out for strangers to find.
McNabb was actually tried for the killing. He is the one that they believe did the killing. Cortney Bell, McNabb's first cousin and methamphetamine abuse partner, was found guilty of the murder in the second degree, cruelty to children in the second degree, and felony contributing to the dependency of a minor in connection with the death of her daughter Kalia. The sentencing produced some testimony that's not really fit for YouTube in that it had certain graphic descriptions of aberrant behavior by McNabb, but once McNabb was asked to speak for himself, he denied having done the crime. This produced this sort of noteworthy and yet cringeworthy exchange that McNabb never saw coming.
I feel like there was things that were allowed to be said that should have never been allowed to be said. It didn't have nothing whatsoever to do with the case and what was being said. Just because somebody has domestic abuse issues with their spouse doesn't mean that they would put their hands on their kids, which has also been pretty much proved that I've never touched my kids in any harmful manner whatsoever. I've never harmed my kids. I didn't even hear anything that said that I had done anything to her in front of the kids. That's all I got to say. I would never do it. I'm innocent.
Well, I can make a lot of comments on what you said. I can make a lot of comments on the trial, but I know that was just be arguing with you or talking with you. I'll ask you one simple question. You claim you're innocent, so you tell me what sentence the man or woman that you claim did this should receive.
If you ever find out who did them, they deserve to be under the jail.
Okay. So they ought to get the maximum sentence.
Most definitely.
Okay. On the crime of malice murder, I sentence you to life in confinement without parole. On concealing the death of another, I sentence you to 10 years in confinement, consecutive or after. Count one. Do you understand each of your sentences?
Yes, sir.
I want to advise you that you have 30 days after today to file a notice of appeal.
When it came time to sentence Bell, the judge was a bit more understanding, but just a bit, and a bit more lenient, again, just a bit. He gave her 15 years in state prison. But her state public defender, it's always a public defender in cases like this, was especially good. He knew, given the optics of the crime, that there was no way a jury was not going to convict the mother because she essentially admitted to being a doper and sleeping with her child's murderer. And this is what the court said when it sentenced Ms. Bell.
Does your client wish to make any statements?
I didn't do this. Y'all know I didn't do this.
Ms. Bell, you and I had a conversation
We did.
back in chambers on Wednesday, remember, morning? And at the time I told you there's a difference between the reality of the situation and what you think. I explained to you exactly why you were being charged with the crimes. It wasn't that you knew about the murder, it wasn't that you anticipated the murder, it wasn't that you planned the murder, any of those things. It was simply that you created an environment that caused your children to be put second and Mr. McNabb to be put first. As the state said in their closing, and they used the example of a rattlesnake being thrown into a room and the child being put into there. Well, your whole claim is I took him back because I wanted to have a family. In that analogy the state used, it's just kind of like saying, your child's dead from a rattlesnake bite. Why would you put it in there? And you responded, well, I just wanted her to enjoy nature.
Now, the plaintive wails of Ms. Bell just are kind of heartrending. They show this shocked and almost confused individual. Now, after the sentence, the appellate defenders went to work. Now, one of the most difficult and uphill battles you can fight on an appeal is a fight about the sufficiency of the evidence. And I should explain why that is. That's because when you fight about the sufficiency of the evidence, you are fighting about only one side of the evidence. In other words, if you have information or evidence that comes in from the actual defendant and they claim they were in Tuscaloosa when this all went down, that's an alibi defense. If they are convicted, the court doesn't get to rely on that evidence. The only evidence that it can consider in determining whether there was sufficient evidence is evidence that could potentially support the verdict. And so it's very, very difficult because the analysis is really only one way. And, that's a pretty big hurdle for almost anyone to overcome.
Hey folks, please excuse the interruption, but let me ask you if you would, if you haven't already, please subscribe. And if you would, hit that like button and maybe even leave a comment. That tells YouTube that this is a valuable video and they'll refer it to more people. It helps me out a lot and I appreciate it. Thank you.
Now, most courts find that if the jury convicted the person, there was enough evidence. But the Georgia Court of Appeals in the first instance and the Georgia Supreme Court in the second did something almost unheard of. They ignored McNabb. They ignored the admitted drug use. They parsed the evidence that was produced, and they issued an opinion overturning Bell's conviction. The fact is that in many cases where someone looks like this, that's all the jury needs to hear. He's tatted up, he's a small guy who acts like a big man, and he later admits he's scared to go to jail. Not exactly Charlie Manson, but much like anyone in Charlie Manson's orbit was tarred with the same brush, anyone who's in this clown's orbit is going to be tarred with the same brush, and that's especially true where he's sleeping with his first cousin. In other words, Bell's conviction for McNabb's crimes probably resounds in the drug use and the sort of incestuous relationship in that case. It's not actually incest in Georgia, oddly enough, but at any rate, here is what the Georgia Supreme Court said about Bell. The evidence presented at trial showed the following. In October 2017, Bell lived with her boyfriend and co-defendant Christopher McNabb and their two children, CM, who was 2 years old, and the victim, who was born on September 23, 2017. On the evening of October 6, 2017, Bell and McNabb smoked methamphetamine and later went to bed in the bedroom while their children slept. They both got up the next morning at 5 a.m. to change Kalia's diaper and feed and dress her in clean pajamas. Bell then fell asleep on the living room couch until she was awakened around 9:30 by the sound of McNabb's phone. He received a text message. Bell went back to sleep until 10:30 a.m. when CM woke her and said that Kalia was gone. Bell called 911 after she couldn't find Kalia, but found her pajamas on the bathroom floor. Bell told investigators that she had last been with Kalia at her 5 a.m. feeding, and that both children were okay when she was awakened at 9:30 a.m. by the sound of McNabb's phone. While being questioned by a sheriff's deputy, Bell stated that she did not know of anyone who would take Kalia, but that McNabb had been involved in a fight with a friend, Matthew Lester, about 6 weeks earlier. She also said that McNabb had never hit her, that she and McNabb were not on drugs, and that she had not smoked marijuana in 6 weeks, had not smoked methamphetamine for at least 3 years. There were no signs of any type of trauma in the bedroom where Kalia had been sleeping with her sister, and no signs of forced entry into the home. Kalia's body was discovered the next day in a wooded area close to her home. The autopsy revealed that she died from blunt impact injuries to her head and that she had numerous fractures to the top and base of her skull. So, at the outset, she's not exactly Parent of the Year material, right? Normally, at this point, some courts would just waggle a finger and refuse to look critically at the evidence. But not Georgia. Initially, she was charged and convicted of murder in the second degree, cruelty to children in the second degree, and felony contributing to the dependency of a minor. Now, the Court of Appeals actually reversed Bell's convictions for second-degree murder and cruelty to children, concluding that the evidence was insufficient to charge her or support those charges under the evidence. So Bell was basically automatically acquitted of those by the opinion. It affirmed her conviction for felony contributing to the dependency of a minor. In support of its conclusion, the Court of Appeals relied on evidence showing that Bell had used methamphetamine and marijuana on a regular basis and allowed McNabb and others to do the same in her house, and that McNabb had hit Bell both before and after Kalia was born. I think that's a rather interesting way of blaming the victim. The indictment alleged that Bell caused Kalia's death by failing to provide proper parental care and supervision necessary for Kalia's well-being, said act resulting in Kalia being a deprived child. A person commits the crime of contributing to the dependency of a minor when such person willfully commits an act or acts, or willfully fails to act when such act or omission would cause a minor to be adjudicated a dependent child. A dependent child, for the purposes of the appeal, was defined as a child who had been abused or neglected and was in need of the protection of the court. More importantly, to sustain a conviction for felony contributing to the dependency of a minor, as charged here, the state had to prove an additional element, that the act or omission that created the child's dependency had produced a particular result. By the plain terms of the statute, to be guilty of a felony of contributing to the dependency of a minor, the act or omission that created the child's dependency must have resulted in serious injury or the death of the child. The court then went on to analyze the case in terms of proximate causation. Proximate cause is that which in a natural and continuous sequence, unbroken by any efficient intervening cause, produces injury and without which the result would not have occurred. In this case, an efficient intervening cause was the action by McNabb. The child would not have died other than the fact that McNabb crushed the child's skull. So there was clearly a problem with the chain of causation here. And that's what the Court of Appeals actually found, that there was no proximate causation. Now, they analyzed the state's two theories, and they found them wanting. And as a result of that, they overturned the conviction. This was an especially good result and an especially thoughtful and well-written opinion on a case that I think a lot of people had opinions about. Maybe people think the young lady ought to be thrown under the jail, like McNabb suggested. But in truth, everybody makes mistakes, and you certainly can't help who you love. And if you happen to love someone like McNabb, you're going to find yourself in this situation. That's one of the reasons why I tell people all the time, if you're in an abusive relationship, get out of it, because nothing good can come of an abusive relationship. So that's what I have for you today. I'm sorry I can't go much further on this because my voice is failing again. If you have the option today, I would love it if you could take a moment or two and do something nice for folks. And otherwise, I hope you'll have a marvelous day. And if you would, drop by and see me here tomorrow at the beach.
If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.